2001 to 2002 would have been a terrible time to be a Muslim refugee seeking protection in Australia. The Howard government used special forces to detain refugees aboard the container ship Tampa. They falsely accused other refugees of throwing their children overboard. The Twin Towers were attacked in the United States. All of this was used to hype up fear in a way that was extremely successful, leading the Howard government to a resounding election victory in November 2001. After the election, they doubled down, and one of their new methods was a privative clause intended to deny refugee claimants any access to the courts to review decisions on their protection applications. Plaintiff S157 was a refugee applicant whose claim was denied after the decision maker considered material which was never disclosed to Plaintiff S157 and which they never had the opportunity to respond to. They appealed to the court to test the privative clause. The argument put on behalf of Plaintiff S157 started with Section 57(5) of the Constitution, which confers original jurisdiction on the High Court in all matters in which a writ of mandamus or prohibition or an injunction is sought against an officer of the Commonwealth. They argued that this means that any attempt by legislation to restrict the ability of people to seek mandamus or prohibition or an injunction against an officer of the Commonwealth would be invalid, because the legislation would be removing a power granted by the Constitution. The High Court found that a privative clause can be effective to prevent review of a decision. However, if the supposed decision is made incorrectly due to a jurisdictional error, then it is no decision at all. And if it's no decision at all, then it cannot be a decision protected by a privative clause. And if it's not a decision protected by a privative clause, then it can be challenged in the federal courts. The majority judges said the jurisdiction of this court to grant relief under Section 75(5) of the Constitution cannot be removed by or under a law made by the Parliament. Specifically, the jurisdiction to grant Section 75(5) relief where there has been jurisdictional error by an officer of the Commonwealth cannot be removed. Even if there is a privative clause in place, an aggrieved person can still seek judicial review if the decision is infected with jurisdictional error.